Not just for marijuana use, for all drug use. The legislature could do that. The legislature could say, we don't think it's a good use of money and resources, state money and resources, to use the criminal justice system to deal with this public health problem of drug use. They could remove that completely. Now, the federal government might not like it. The federal government might say, hey, that makes it harder for us to do our job of enforcing drug laws, but they couldn't strike down a negative. They can't go to the legislature and say, put those laws back on the books. They can't do that. And this is why, and I think Alex is right about the most likely place for litigation that would be most dangerous is around these regulatory schemes that would have to be set up by local governments. But if you think about it this way, the response to that, and you talk about risk, I mean, this is the risk that I would say to my bosses at DOJ if I was advising them about whether or not to go after the local regulatory systems. I would say, look, if California wants to, it can completely deregulate. The counties don't have to have, the state legislature could say, you know what, sale of marijuana is legal throughout the state without the counties doing anything, without any regulatory framework. If the state can take away all criminal penalties for all marijuana activity, which I believe it can, clearly it can under the 10th Amendment and Federalism, if it can do that, then why can't it take away the criminal penalties from a smaller subset of that activity? Right? They're saying, we're going to leave these penalties in place for the vast majority of it, but for a little piece of it, we're going to take those penalties away. And that's what they've done with the medical marijuana laws. And I think that that's what, so if it's against, if the federal government could preempt a regulatory scheme, California can just come back and say, okay, no regulatory scheme. We're just going to remove all our criminal penalties. And it seems the federal government would prefer to have some regulation in place than none at all.
A question for Eric Stewart.
You spoke about the theory in the San Diego case, and the opponents of the law didn't have a sound theory. What's your thought about the application of the Single Convention on Narcotics, which, as I recall, requires that the signatory nations have a single agency to regulate drugs such as cannabis? Would that be a theory that the courts might look at more favorably in trying to strike down the California law?
It's an interesting question. I have some familiarity with the Single Convention because we encountered it in other litigation that we have ongoing right now on behalf of a professor at UMass Amherst who wants to grow marijuana for medical researchers to use to take through the FDA approval process. One of the arguments that the DEA has made is we can't allow that. There needs to be just a single agency in control. Here's the thing, though. The Single Convention has to comply. I mean, our Constitution trumps the treaty, right? The treaty can't be enforced in a way that is unconstitutional here in the United States.
And that's what the Supreme Court has ruled?
That is the justification. I'm trying to think of where it resides, but that's justification that you've seen from these countries that are also signatories to the Single Convention that have recently removed criminal penalties for it. They say that treaty provision interpreted that way violates our constitutional framework and structure. And in the United States, so I don't know, Eric, if the Supreme Court has ruled specifically on that issue, but I do know that the Constitution trumps, that a treaty is like a statute, but in terms of where it is hierarchically underneath the Constitution, and then the statute, the treaties, and then federal and state statutes. So what the federal government can't do because of the Constitution, because of federalism, because of the 10th Amendment, is require states to have, now, what they could do, and I don't want to give anybody ideas that they don't already have, but Congress could certainly amend the Controlled Substances Act and take away this non-preemption clause. The clause that you were reading, Roger, that says only if there's a positive conflict does the federal government occupy the field. Congress could amend the statute and say, all right, we occupy the field. States, you can no longer have any laws or regulations on your books about drugs. But as a political matter, I think that will never happen.
Thank you.
One thing I'd say is just briefly to follow up. I think you're exactly right that they could do that, and I think politically it never happened. And one of the other reasons is if they tried to occupy the field, they simply couldn't do it. I mean, for reasons that you know too, resource-wise, that the federal government, I mean, is entirely dependent on states for the enforcement of the vast majority of drug laws. I mean, even when you're talking about conspiracy sales, higher level offenses, still the majority of the prosecutions are happening at the state level. And so, the federal government, there's sort of only so far they can go because they don't want to occupy the field, because if they did, that would be a huge problem.
Well, it's likely that the federal government's going to go the other direction, at least with regard to marijuana. That's at least how the culture is changing and how the laws are changing with them. So don't you agree that we need a change in federal law? We can't continue this way with, let's say California legalizes marijuana. Washington State almost got it on the ballot ourselves this year, and it's likely in 2012. So we need a change in federal law as well, of course. I don't know what suggestions or recommendations you have.
One of the things of this, I talked a little bit about this in an article I've come out in the Chapman Law Review, I think maybe a month, 2 months, it's going to be published, is the idea of where federal law should be in this era of state reforms. I think Allman made a great point, which is that, that a state, if the federal government goes after a tax and regulate scheme, be careful what you wish for, because the state could just say, we're going to remove all penalties. And one of the arguments I make in this piece is that the federal government, both because of anti-commandeering principle and because of the resources issue, doesn't really have the power to stop these state reforms. They certainly have the power if they wanted to go and arrest people themselves, they don't have the resources to do it. So they're left with second best options. If you're, from the perspective of a prohibitionist, who believes strongly in prohibition at the federal level, when a state makes, say, a medical marijuana law or, Prop 19 passes, the federal government's left with second best options. And so I think, and my hope is that, at some time in the future, as there's more and more of these state reforms, the federal government will start to sort of realize that and think the best course of action for us is to recognize that these state laws exist, not endorse them by any means, but try to put some sort of federal checks on them ourselves. Perhaps have, federal law structured in such a way that a state that were to enact this kind of reform would have to, have certain checks against negative externalities to other states. They might maybe say, if your state you want to enact this, you have to pay a certain, type of fee to neighboring states to offset their enforcement, or things like that. I don't know what, if you'll ever sort of reach that point politically, but it does seem that at some point, federal officials will have to look and say, you know what, we're not able to stop these state laws, so perhaps we should try to constrain them in some way, or work with them in some way.
Maybe it's just because of my age, I want to play devil's advocate for a moment and say I never underestimate body politics to do something stupid. And I can easily see, we've got Eric Holder, and we have the U.S. Justice Department coming out and changing course and saying, we're just not going to put our resources, which, many of us, probably all of us would say that's the right thing to do. That was a smart policy decision. But that was a decision made by a certain administration. You can have another administration coming in for whatever reason, to whip up the masses on, the issue, and I don't want to get too deeply into this because it's another issue I know that's playing out in California, but the whole issue on gay rights. Remember what happened just a few years ago when, the Bush administration was very happy that there were certain issues that were being put before every state, or a lot of states, because it got their supporters out and it energized their supporters. And you can see this, I can see marijuana as being, that type of issue. And I've seen some of the government films going way back when. And you can create a real fear among the body populace.
I just learned that marijuana causes insanity.
Among other things.
The American Bar Association is here in town, and the 8,000 lawyers are going to be considering gay marriage. And I think there's also a resolution that is pending from the King County Bar Association about giving states the authority to regulate marijuana. I think the American Bar Association didn't want to deal with gay marriage and marijuana at the same time. So the marijuana resolution is likely to come up at its next meeting. We're running out of time here in this first panel. Very much appreciate this discussion, but what should happen? State's Attorney Bobby Sand from Vermont has suggested that the federal government have jurisdiction over marijuana in large amounts, and the states be given authority to regulate marijuana in smaller amounts. I don't know what the threshold would be, but is that a good idea? Or what about the model that we have from the 21st Amendment, which is for the federal government simply to yield to the states the regulation of marijuana state by state? We have a patchwork of state laws in alcohol. Or should we continue some sort of federal-state partnership under the Controlled Substances Act with the DEA enforcing it? What are your suggestions as final thoughts?
Well, I mean, I think that the model, something along the lines of the Truth in Trials Act, which they're trying to act for medical marijuana, something that is a more targeted reform, at least in the short term, of saying, look, we're going to, at least to some extent, acknowledge within federal law these state laws exist. Either give people an offense if they're prosecuted federally to say I was in compliance with the state law, or perhaps give people more than an affirmative defense and say if you're in a state that's an activist and you're in compliance with the law, then you have immunity from prosecution to some extent or something. I think that would be a good system. I think also potentially a system in which federal government only goes after people certain amounts. The problem with that is that then you still have the black market. You don't really, from a policy perspective, especially as one who, a large part of the reason I favor tax regulated system is because of the terrible consequences that prohibition has for organized crime. If you have something where the federal government says, oh, well,